Law is symphony of order and justice intertwined within the fabric of society. Law is a colorful tapestry made from standards of history, philosophy, and human experience that extend beyond its formal definition. However, the law is more than just a series of law written in stone. It is ongoing discussion between legislators, legal scholars, and the very people it ties. Understanding law entails more than just memorizing legal vocabulary. It also entails comprehending the stories underlying the secrets, the philosophies that determine judgment, and the human values that shape evaluation.
Okay. From the case that happened, we can conclude that the issue is, first issue is, can Mr. Pitt refuse the agency contract between Healthy Syndrome Berhad and Queen B despite the potential damage to the company's reputation due to Queen B's action with Kidslim? Okay, the next issue is, should Mr. Pitt, the CEO of Healthy Syndrome Berhad, ratify the contract between Queen B and the company despite Queen B's disregard for an urgent notice to stop selling a dangerous product? Okay, next issue is, can Queen B's contract with Healthy Syndrome Berhad be ratified by Mr. Pitt, the CEO, despite her unauthorized actions concerning Kidslim, a potentially harmful product?
I will continue to the law. According to the research question, this case focuses on ratification. Ratification means confirmation or approval of the unauthorized act of an agent by his principal. Under the Contract Act 1950, Section 149, if acts are done by a person on behalf of another party without his knowledge or authority, he can choose to ratify or disapprove of those acts. If he ratifies the acts, the same result will follow as if they had been performed by his authority. Next, under Consumer Protection Act 1999, CPA, Section 8(2)(b), this section prohibits a trader from supplying unsafe goods. Kidslim, if proven to cause undesirable side effects, could be considered an unsafe good under this section. Furthermore, Section 14, this section allows consumers who have suffered loss or damage due to a defective product to claim compensation from the trader or manufacturer. Queen, as the seller of Kidslim, could be held liable for compensation under this section. Lastly is Section 2(3). This section gives the Ministry of Domestic Trade and Consumer Affairs the power to issue compulsory recall order for unsafe goods. If Kidslim is deemed unsafe, Queen may be required to recall all unsold box of the product under this section. That's all from me. Thank you.
From the case, we have some examples of case ratification. Firstly, case Kegley Maxter & Co. versus Duran 1901 AC240. Okay. This case, an agent was authorized by the appellant to buy wheat at a certain price. The agent exceeded his authority and bought it at the higher price. However, the agent contract in his own name. Hence, the principal was not liable for the act of an agent who did not profess to be an agent when he entered into the contract. The second example of case certification is case Kellner versus Baxter 1866 NR2 CP 174. This case about a contract to buy a hotel by an agent on behalf of a company which was about to be formed could not be ratified by the company since it did not exist at the time. This case held, a stranger cannot by subsequent ratification relieve the promoters from the responsibility of liability. Okay, the third example of case ratification is case Grover and Grover v. Matthew 1910 2KB 401. Okay, this case about ratification on a policy of fire insurance was made after a fire had happened. The principal ratified the agent's act after the premise had been destroyed by fire. Therefore, the ratification was held to be ineffective because the ratification on agent's act should be done before the loss of goods. Okay, this case held is according to S153 CA 19650, any ratification made must not bring any damage or termination of right or interest to third party.
By ignoring the recall letter and continuing to market Gippsland, Queen B violated her duty of obedience. This breach most certainly causes harm to third party, thereby subjecting Mr. Fit to product responsibility damages. When selling Gippsland before the recall notice, Queen B acted under express authority, first sale contract. Queen B disagreed Healthy Sdn Brd request to stop selling Gippsland, infringing on her duty of obedience and potentially endangering third parties. Queen B disobeyed Healthy Sdn Brd instruction to stop selling Gippsland. This violated her duty of obedience and puts the company at risk due to the product safety concern. Healthy Sdn Brd fulfilled its disclosure responsibility by informing Queen B of the product's adverse consequences. By continuing to sell Gippsland after the notice, Queen B acted beyond her actual authority. This means any contract she enters are not automatically binding on Healthy Sdn Brd. Given Queen B violation of duty, Mr. Fit is within his right to refuse to ratify the contract with third party. However, Queen B legal activity could have a detrimental influence on Healthy Sdn Brd reputation. Given Queen B disobedience and the possible harm caused by the product, Mr. Fit refusal to approve the contract is understandable. If ratified, Healthy Sdn Brd would be held legally liable for Queen B Act. Potential liability of Queen B is Queen B may be held accountable for consumer losses if she acts outside the scope of her power by continuing to sell Gippsland despite the notice. She did take adequate precaution in promoting and selling the product. Her action causes consumer to suffer harm that may have been avoided. Meanwhile, Mr. Fit has the right to refuse ratification. Mr. Fit has the authority to refuse ratification of Queen B Acts based on Queen B knowledge of the product risk before and after the notification, the extent to which consumer have been harmed. If ratification is granted, Healthy Sdn Brd reputation could suffer.
I will explain about the conclusion. So for the conclusion, in this complicated scenario, it is conclusively demonstrated that Queen B, who act as an agent for Healthy Sdn Brd, face legal challenge arising from the sale of Gippsland product despite the company receiving a recall notice. As a result, some critical points should be considered when advising both parties in accordance with agency law. Legal guidance to navigate the complexities of agency law, potential liability and available defense. Both parties should obtain independent legal advice. In order to mitigate potential legal repercussion, Queen B to think about having a conversation with Mr. Fit to ascertain the rationale behind his choice and investigate the feasibility of ratifying the contract. When deciding whether or not to ratify the contract, Healthy Sidang Berhad may need to consider the overall effect on its goodwill and reputation, as well as the legal and business ramification. The exact term of the agency agreement, the authority given, and the circumstances surrounding the product recall will ultimately determine how the matter is resolved. To handle legal issue and potential fallout from the sale of Kip Slim, Queen B and Healthy Sidang Berhad need to be in constant communication with one another and with legal counsel. Thank you.